Here we go again. Karen Reed back in court, this time trying to dismiss a part of the civil lawsuit brought against her. Reed was acquitted of killing her Boston police officer boyfriend, John O'Keefe, in June, but the O'Keefe family is now suing her for wrongful death. Her attorneys promising a forceful defense, saying nothing and no one is off the table. Joining me now, Chief National Correspondent Matt Gutman, also former federal prosecutor Neama Rahmani. So, Matt, let's talk about this case and what it's actually about.
Well, this particular case is about responsibility, right? The family of John O'Keefe felt like justice wasn't done in the first two trials in which Karen Reed faced second-degree murder trials for allegedly running into her Boston police officer boyfriend, John O'Keefe. There were mistrials, and then she was essentially acquitted of the most serious charges. She was convicted of driving under the influence and given a year of probation. So the family actually, after the first trial, before the second trial, launched this civil suit. And what they're saying is that she was responsible civilly, as well as the two bars that served Karen Reed alcohol. And there's quite a bit of discrepancy about how much she drank that night. She told me in our interview that she drank about 4 drinks. Prosecution thought it was 8 to 9. Whatever it was, a jury found her guilty of driving under the influence, and the family believed that the bars should be held culpable for serving someone who was already drunk and then ended up committing a crime. So that's where we are right now. They're asking for at least $50,000. Typically, that's kind of just a starter number. But I think what the family also wants is some justice. And they're hoping for an O.J. Simpson type of scenario in which he was found culpable in the civil trial, acquitted in the murder trial, the criminal trial. But, you just mentioned it, Kira. Her attorney, who's the same attorney for the murder trial, Alan Jackson, said basically, we're going to come out swinging. There are going to be some surprises today. And there have been. I'm going to say that for the next question because I know you're going to want to get to that. But basically, they're saying, we're not going to take this. We're going to fight it. And we're going to seek a dismissal for, significant portions of this case, Kira.
So then, Neema, is there a world in which Reed will have to pay O'Keefe's family? And if so, what are the chances O'Keefe will actually get that money?
Well, there is a world, and Matt talked about it. The O.J. Simpson case obviously is the big example. But really, when you're talking about a civil case, because it's just about money, not to say money isn't important, the standard is very different. So in the criminal case, we've all heard it, beyond a reasonable doubt. That's the highest standard under the law. You have to get a unanimous jury, 12 out of 12. Well, in the civil case, it's a much lower standard. It's preponderance of the evidence. That means slightly more likely than not, 50.1%. And we know there were different theories in this case. One, which was the Commonwealth's theory, was that this was an intentional act. It was murder. The other would be that this was just an accident, right? And that's the manslaughter charge. Well, an accident is enough for a civil verdict. And of course, there was the argument made by the defense that this was all a setup and a cover-up. Well, of course, that wouldn't have been an accident at all. The other factor that to consider is you don't need a unanimous verdict in most civil cases. And in Massachusetts, you just need 10 out of 12. So it is a lot easier. And I expect that the civil lawyers won't have many of the same problems that the prosecutors had. You and I have talked about this case a lot. Michael Proctor, one of the worst witnesses that I had seen. The case really was botched in many ways. So I think you'll have a really different perspective by John O'Keefe's family lawyers in the civil case.
All right, we'll track it. Matt, Neema, thank you both.